two categories: guns and drugs. And more drivers talk themselves into criminal charges over these two subjects at a traffic stop than over almost any other topic this channel has covered combined. Not because they were doing anything wrong. Not because the officer caught them in the act of anything. Because the moment either word enters the conversation, gun, weapon, weed, pills, anything at all, something shifts in a driver's head, and the instinct to explain, to clarify, to get ahead of it before it becomes a problem, takes over completely and immediately. And every single word spoken in that instinct is recorded on body cam, transcribed eventually if it matters, and available to a prosecutor for as long as the case exists, which can be years. This video covers exactly what never to say the moment either topic comes up, why each individual instinct backfires in the specific way that it does, the precise legal mechanism behind each one, and the exact replacement words that protect you instead. We are going deep on this one. Subscribe to this channel, like this video, and drop a comment below with your own traffic stop experience, whether guns or drugs ever came up for you or not. Because every story shared here helps another driver walk into their next stop more prepared than they would have been otherwise. Before the 5 specific things, you need to understand why guns and drugs occupy a fundamentally different category from almost everything else covered in this series. Because understanding the stakes is what makes the discipline required here feel necessary rather than excessive. A question about your destination, your speed, or your insurance status produces, at worst, an administrative consequence, a citation, a fine, a point on your license, an increase in your insurance premium. A question that touches on a firearm or a controlled substance can produce a felony charge, a mandatory minimum sentence in jurisdictions that impose them, the permanent loss of firearm rights even for an otherwise lawful gun owner, immigration consequences for non-citizens that can affect status regardless of the underlying outcome of the case, professional licensing consequences, and in the case of items that were entirely legally possessed, can still produce hours of investigation, a vehicle impoundment, an inventory search, and a permanent law enforcement contact record even when nothing about the underlying situation was ever illegal in the first place. The stakes are categorically higher than a speeding ticket, and the instinct to talk your way through the moment is categorically more dangerous because of it. This is also the area of any traffic stop where the gap between what feels like the safest, most transparent thing to say and what is actually the safest thing to say from a legal standpoint is the widest of any topic in this entire series. Almost every instinct a reasonable, law-abiding, completely innocent person has in this specific moment is the wrong instinct to act on. Not because those instincts are foolish or because the person having them is unintelligent, but because those instincts were built over a lifetime of ordinary social situations, where explaining yourself clearly and helpfully genuinely does resolve misunderstandings. A traffic stop involving a gun or drug question is not an ordinary social situation. It is an evidentiary moment, and every word spoken inside it is being weighed, in real time, against a charging decision that has not yet been made and that your own words can tip in either direction. The first thing never to say, the moment a firearm comes up in any way, in any context, is some version of "I have a permit," "it's totally legal," "don't worry about it," or any other phrase where you personally declare the legal status of the situation. This sounds, on its surface, like the single most reasonable, transparent, cooperative thing a law-abiding gun owner could possibly say. And that is exactly why it is said so often and exactly why it causes so much unintended damage. Saying it's legal does several things simultaneously, none of which actually help you and several of which actively work against you. First, it confirms the presence and the general location of a firearm before the officer has independently verified a single fact about it. You have done his confirmation work for him, voluntarily, on camera. Second, this disclosure frequently and immediately triggers a pat-down, a request to secure the weapon for the duration of the stop, or in order to step out of the vehicle entirely, none of which are inherently a constitutional problem given the existing case law this channel has covered on firearm encounters, but all of which convert what might have remained a routine 2-minute traffic stop into an extended weapons handling encounter with its own physical risks and its own extended timeline. Third, and most critically, saying it's legal is your own personal legal conclusion about a complex regulatory framework. It is not a fact, and it is not something the officer is obligated to simply accept at face value. If anything about your specific permit's current validity, your state's specific vehicle storage requirements, the reciprocity status of an out-of-state permit in the jurisdiction where you are currently driving, or a carry zone restriction you were not aware of, is even slightly different from what you personally believe to be true, you have just voluntarily walked yourself directly into that exact problem, on camera, in your own words, before anyone asked you a single specific question about any of those details. The safer approach, covered at length in this channel's dedicated video on the "Are you armed?" question, is to know your specific state's disclosure law in advance, whether you are in a mandatory disclosure state, a duty to inform only if asked state, or a state with no disclosure requirement at all, and to follow the precise script built for that specific category, rather than offering your own improvised legal characterization of the situation in the heat of the moment, under stress, with lights flashing in your mirror. The second thing never to say, in either the firearm context or the controlled substance context, is anything that volunteers a specific location before you have been asked a direct question requiring it. It's in the glove box. It's under the seat. There's a little bit in my jacket pocket in the back. It's in my bag in the trunk. Every single one of these statements performs the officer's search for him before any search has even been requested, let alone justified under the Fourth Amendment framework this channel has covered extensively. You have just handed over a roadmap, voluntarily, with no question requiring you to do so. If a firearm is the subject, the location statement tells the officer exactly where to direct his attention and exactly what to expect when he gets there, which removes any ambiguity that might otherwise have existed about whether what he subsequently finds was anticipated, expected, or a genuine surprise. And that distinction matters significantly in how the encounter gets documented and characterized afterward. If a controlled substance is mentioned, hinted at, or even vaguely referenced, the location statement is, by itself and on its own, an admission of possession at that specific location, which happens to be precisely the element a prosecutor most needs to establish to prove a possession charge. None of this information is legally required from you under any circumstance covered in this series. If you are asked directly where something is located, the response from every other video in this channel applies here in full and without modification. A calm, simple invocation of your right to remain silent, stated once, without elaboration, without qualification, and without any further explanation of why you are invoking it. The third thing never to say is "it's not mine, it's my friend's, my cousin borrowed the car last week," or any other detailed explanation of whose item something is and exactly how it ended up in your vehicle. This feels, to almost everyone who says it, like the single most obvious, honest, exculpatory thing available to say in the moment, and it is, at the same time, one of the most common and most effective ways that drivers create legal exposure for themselves where none needed to exist in the first place. Explaining whose item it is first requires you to confirm, implicitly, that you know the item exists and that you are aware of its presence in your vehicle. That confirmation establishes knowledge and proximity, two of the specific elements often required to prove possession, including the legal theory of constructive possession under many state statutes, even when you personally never touched the item and never intended to use it. The explanation also creates a separate, independent inconsistency risk that has nothing to do with whether your story is true. If your account of whose item it is differs even slightly in detail, timing, or phrasing from what a passenger says when asked the same question separately, or from what later turns up in a phone record, a text message, or any other piece of evidence, that inconsistency becomes a credibility problem at trial regardless of who actually owned what, and regardless of how innocent the original explanation genuinely was. You are not required, under any law covered in this series, to explain ownership of anything found in, on, or near your vehicle. "I am invoking my right to remain silent" covers this situation completely and entirely, without requiring you to construct, on the spot, under pressure, an explanation that might not hold up exactly the way you intended it to when you first said it. The fourth thing never to say is any minimizing language whatsoever. "It's just a little, it's only for personal use, it's just an old one I completely forgot was even in there." The word "just" in every single one of these constructions feels like it is reducing the seriousness of whatever is being discussed, softening the moment, signaling to the officer that this is not a big deal and should not be treated as one. Legally, it accomplishes none of that. It's just a little is still, in full, an unambiguous admission of possession. The word little does not change the legal element being established. It's only for personal use is, depending on the specific jurisdiction and the specific substance involved, sometimes legally relevant to the separate distinction between simple possession and possession with intent to distribute. But critically, you are not the person who gets to make that determination at the roadside, and offering your own characterization of intent does not bind a prosecutor to accept it later. It only adds your own voluntary statement about your state of mind to a record that did not previously contain one. It's just an old one I forgot about, specifically in the firearm context, can actually create an entirely separate legal problem in some jurisdictions around proper storage compliance, registration lapses, or transport requirements that the driver had no idea even existed until the moment they said the sentence that revealed it to an officer who is now obligated to act on what he has just been told. Minimizing language does not minimize anything in the eyes of the law. It accomplishes the opposite. It adds specific, voluntary, recorded detail to a record that, before you spoke, did not contain that detail at all. The fifth thing never to say is any explanation of why you have it, why it is there today, why today of all days is somehow different from every other day. I just got back from the range an hour ago. I am holding this for a friend who could not carry it themselves. I was supposed to drop this off for someone later tonight. I only smoke on weekends, and this is just leftover from before. Every single why is, at its core, a narrative, and narratives are exactly what a criminal investigation is structurally built to test, to cross-reference against other evidence, and ultimately to use against you regardless of whether the underlying story happens to be completely true. A true story that cannot be independently verified in the moment, at the roadside, under time pressure, is treated by the legal system in exactly the same provisional way as a false one, right up until the moment it can actually be proven true. And proving it true is precisely what trials, evidentiary hearings, and the entire criminal justice process exist to do. It is not the job of a roadside conversation. You do not owe an officer a why, under any legal framework covered anywhere in this series. I am invoking my right to remain silent, and I would like to speak with an attorney replaces every single why you might otherwise feel a strong, completely understandable, human urge to offer in that moment. Here is the constitutional foundation underneath every one of these 5 things, because each one connects to a specific, well-established legal principle this channel has covered before, and understanding that foundation is what makes the replacement language feel grounded in real law rather than arbitrary caution. The Fifth Amendment protects you from being compelled to provide statements that could incriminate you, and in the specific context of firearms and controlled substances, that protection is doing more critical work than in almost any other category of traffic stop conversation covered in this series, precisely because the consequences attached to a single admitted fact are categorically higher than almost anywhere else. The Second Amendment, addressed at length in this channel's prior video specifically covering the "Are you armed?" question, protects lawful possession of a firearm as constitutionally protected conduct under Heller, McDonald, and Bruin, but that constitutional protection covers your underlying right to carry. It does not create any obligation for you to narrate the specific details of that carry beyond exactly what your specific state's disclosure law actually requires of you. Terry v. Ohio still governs whether any subsequent pat-down is constitutionally justified at all. The mere disclosed presence of a legal, properly permitted firearm does not, by itself, establish the separate and additional element that you are presently dangerous, which is the distinct prong that Terry independently requires before a pat-down may lawfully proceed. None of the 5 things covered in this video are legally required of you in any jurisdiction in this country. Every single one of them is an explanatory instinct that feels honest, transparent, and protective in the moment it is spoken, and that functions, on the actual permanent recorded record, as voluntary evidence handed over for free, before anyone with legal authority ever had to work to obtain it. The officer will sometimes push for more once you have invoked silence on a gun or drug question, and knowing what that pushback typically sounds like in advance is what allows you to hold your position calmly rather than being caught off guard by it. If the officer says, "I just need to know if it's loaded, for safety," this is a legitimate sounding safety framing, and your response can acknowledge the safety interest without reopening the door you just closed. "Officer, for safety, please treat any firearm in this vehicle as if it is loaded." Beyond that, I am invoking my right to remain silent. If the officer says, "If it's legal, why won't you just say so?" The implication that silence equals guilt is a pressure tactic this channel has covered in multiple other videos, and the response does not change. I am invoking my right to remain silent. If the officer says, "I already smell it," there's no point in not telling me. Whether or not that claim is accurate, your obligation to respond to it has not changed, and confirming or denying anything at this point only adds detail to a record that the smell claim alone, as covered in this channel's video on that exact topic, may not be sufficient to support on its own. I am invoking my right to remain silent, and I do not consent to any searches. If pressure continues and the encounter begins to escalate toward a search or an arrest, I would like to speak with an attorney before answering any further questions. If handcuffs come out at any point, I want an attorney. For words said once, everything stops there. Here is the complete replacement language for all 5, consolidated in one place so you can practice saying it out loud before you ever actually need it. Instead of confirming legality yourself, follow your specific state's disclosure script from this channel's dedicated firearm video, rather than offering your own legal conclusion. Instead of volunteering a location, I am invoking my right to remain silent. Instead of explaining whose item something is, I am invoking my right to remain silent. Instead of using minimizing language like just or only, say nothing further at all. Silence does not require any qualification, softening, or context to be effective. Instead of explaining why, I am invoking my right to remain silent, and I would like to speak with an attorney. Every one of these 5 replacements is short. Every one can be repeated calmly, in the same words, as many times as the situation requires. None of them require you to be evasive, hostile, sarcastic, or anything other than quiet, calm, and respectful for the entire remainder of the encounter. Memorize these 5 before you close this video, or write them down and keep a copy somewhere you will actually find it later. Never confirm legality yourself. Follow your specific state's disclosure rule instead. Never volunteer a location for anything. Never explain who owns an item found in or near your vehicle. Never use minimizing language like just or only. Never explain why something is there. Replace every single one of these with a calm, simple invocation of your right to remain silent, and add a clear request to speak with an attorney the moment the encounter escalates beyond routine, administrative questioning. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your individual circumstances. If this video kept you from saying even one of these 5 things the next time guns or drugs come up at a stop, it did exactly what it was built to do. Subscribe to this channel and hit the like button right now. Every single like helps another driver find this video before they actually need it, rather than afterward, when it is too late to matter. And drop a comment below with your own traffic stop experience, whether guns or drugs ever came up for you specifically or not, because your story helps shape exactly what this channel covers next, and it might be the exact thing someone else watching right now needed to read before facing the same situation themselves. Stay calm, stay protected, stay free.